So the next panel is going to talk about solutions to the biotechnology patent thicket, which I suppose includes a predicate assumption about the existence of a biotechnology patent thicket, and I imagine that will be a subject for discussion. I'm going to introduce our moderator, who I think in turn is going to introduce the rest of the panel. Becky Eisenberg is one of the leading scholars in patent law and focuses in particular on biotechnology patent law. She is a professor at the University of Michigan, though she's spending the year here in the Bay Area, and we're delighted to have her down here at Stanford, where she got her undergraduate degree before crossing the Bay to Berkeley for her law degree, something I'm familiar with. And she's going to lead us off on our discussion. Becky.
Thank you very much. I'm delighted to be here and to take up this issue, or to lead the discussion at least, of this issue that has been a longstanding interest of mine, which is, what happens as patents become really numerous? Does that create a different order of problem? What kinds of problems does that create? After a decision, to have this panel, which has long been in the planning stages, come together so soon after the decision of the Supreme Court in Mayo versus Prometheus, it may seem like we're singing last year's tune. It might seem like we should be worrying more about the lack of patent protection for diagnostics rather than about the problems that might follow from too many patents. But I think it's entirely possible that the medical diagnostics field could be raising both kinds of problems. That Mayo versus Prometheus doesn't eliminate the potential for patent thickets to impede diagnostic product development, and it's a problem that we need to continue to be alert to. We don't, of course, yet know how broadly or how narrowly the Supreme Court's decision will be read. It seems like there is room for some retreat from the broader possible implications in that opinion, and I certainly hope that our friends from the Federal Circuit will figure out respectful ways to pursue that. Meanwhile, there's a lot of patents out there. Many patents have issued on diagnostics or on bits and pieces of diagnostic products that are likely to dominate future product development. There may now be a new line of questioning as to the validity of those patents, but they continue to enjoy a presumption of validity. They could be asserted. They need to be considered by product developers. And even if we end up with a fairly robust phenomena of nature exclusion from patentable subject matter that impedes certain claiming strategies in the diagnostics area, that doesn't necessarily mean that we will have fewer patents, although perhaps we will have patents of narrower scope, and that will limit their reach and may mitigate somewhat the possibility for an anti-commons arising. More likely, I think, it's going to change the kinds of claims that are allowable. It's going to change the ways that claims are drafted, but there will still be a considerable question as to the reach of those claims. So I think that patent thickets remain a potential problem, particularly for multigenic diagnostic tests that are likely to implicate multiple patents, even if they are of questionable validity. But you don't need to take my word for it, because we have here a fantastic panel of very experienced people who can speak to this issue with the authority of real-world experience of various sorts. We have 4 speakers on this panel who bring different perspectives to bear on the question of patent thickets. Shall I introduce all of you at the outset? Or one by one, you think? Who knows? Our first speaker immediately to my right is Gary Cohen, who is currently teaching at Boston University Law School, but brings to the Academy a wealth of private sector experience in the life sciences as a lawyer doing corporate, transactional, and IP strategy work, among other things. Gary has worked with the leading life sciences companies and is of counsel to a life sciences law firm. He knows the practical issues that confront firms developing multi-gene diagnostic tests. He's given a lot of thought to the challenges of creating patent pools in this space. So I think I'll go one by one. That's Gary Cohen.
Well, thank you very much, Becky and Mark, and special thanks to my friends at WilmerHale for inviting me here today. I'm delighted to be here. Fred Server of WilmerHale and I have been actually debating, thinking about, and working on multigenic, multiplex diagnostic gene patent issues for quite a while in the real world. So this conference is a wonderful opportunity to revisit some of our thinking. Of course, we're meant to be talking about solutions to the biotech patent Thicket. I think we'll find out if they're solutions. They may well be possible solutions. But my role here today really is to set the stage. I'm going to leave it to the panel discussion and to the room here to see if we've actually solved anything, if we're on the right track. I'm going to be talking about why multiplex testing or multi-gene testing is important. There are biological and logistical and actually professional reasons why molecular diagnostics, genomic diagnostics is moving deeply into the multiplex area. We're going to talk a bit about what happens when the patent law meets the genome. We talk about thickets, but thickets come in various thicknesses, right? And they are of varying degrees of thorniness, and those are important things to think about in trying to devise solutions to these problems. I'm going to talk a bit about the cost of quantifying and responding to these thickets, and then we'll try to hack our way through some possible solutions. So why multiplex or many gene testing? This is a definition of patent thickets from the Secretary's Advisory Committee report from a few years ago, a dense web of overlapping intellectual property rights that a company must hack its way through in order to actually commercialize a new technology. And as you all know, we've heard about it. We certainly heard about it from Dean over lunch. Genomic technologies are tremendously complicated. They're tremendously complicated as they intersect with human disease. There's infinite materials out there that explain to liberal arts major lawyers, non-patent lawyers like myself, how amazing the work of my scientist colleagues actually is in this area. This is a graph that I think can be off-putting to the liberal arts lawyers among us, right? This makes us glad we went to law school and not to medical school, perhaps, but it's really not that bad. So you see here in blue various locations or types of tumor that can develop in the body, and you see here in green along this axis different types of proto-oncogenes or different genes that are associated with the evolution of cancers. And on this axis here, and plotted across the floor of the chart, you see the frequency of cancer-associated mutations based upon assessments of these tumor types. And what you can see is that particular mutations show up not just in one type of cancer, but they show up to varying degrees in different types of cancer. And if you look, for example, here at KRAS, you can see that it's very highly expressed. That is, you have a very high mutational rate, if you read it down across the chart, down to pancreatic cancer. But it shows up in other places too. And you can look right here. This is a gene that encodes for HER2. If you're an overexpressor of that gene, Herceptin will work for you. You can see it's expressed, although at a fairly low level, in ovarian cancers, but it shows up in lung cancers too. Now, very few companies, very few labs, very few medical centers currently test for overexpression of HER2 in lung cancers. And yet, if you're the one person or two people or the small percentage of people who overexpress HER2 in lung cancers, you're going to respond to Herceptin. So that's infinitely important to you, right? And so these tests have to be aggregated. They have to be multiplexed as a kind of biological matter, whether you're talking about disease pathways or simply the presence, even in low frequencies, of cancer gene mutations across all cancers. Really what you understand is that it's not the place in the body where the cancer arises, it's the underlying genetic reasons why you've got the cancer. What's driving the uncontrolled malevolent cellular growth. So there's a biological reason why we have to develop these multi-gene tests, and in fact, company I was associated with for the last few years, Foundation Medicine, has a many hundred gene test. Really, it's the only way that you can detect cancer mutations across the entire spectrum of tumor types. Now, the patent problem, of course, arises when you think about the number of patents that can attach to any one of these genes. It's not a one-to-one correspondence, of course. It's not one gene on a panel, one patent. There are method of detecting patents. There are patents of emerging solidity still on isolated genes, as we heard in a panel earlier this morning. We've talked a bit about the use of these genes as probes or primers or component parts of other tests. So there are multiple patents that can attach to any one gene. And of course, if you've got multiple genes on a test, you are going to have multiple patents attaching to any of those genes. And when you start talking about not just 10 or 20 biomarkers on a single assay or single test, but hundreds, if not thousands, you start seeing the proliferation of what emerges as a potential patent thicket. There's also a kind of a logistics or logistical reason why patent thickets can emerge in this area. So here's a representation of a lymph node biopsy in presumably a breast cancer patient. These biopsies produce relatively small quantities of material. And even if you amplify DNA, you're still starting with relatively small samples. Now, industry and testing companies are getting much better at extracting DNA in usable quantities from increasingly small samples preserved in different ways, but the sample sizes are small. And if you have to send a limited quantity of biopsy to not one centralized place that can do the tests, but to different laboratories, 5, 10, 30, 100 different laboratories, driven not by the test itself, but who has IP rights to run the test. You're really going to be pressing pathologists to divide up this limited quantity of biopsy material to make this possible. And again, this is a scenario that is really driven by the presence of IP rights associated with particular testing labs. I just pulled logos off the internet. There's no aspersions cast, maybe a little aspersion here, but not too many for the other players. This creates what I call a kind of professional actionability problem on the other end of this information trail, as these reports on gene mutational status emerge from the labs and flow back to a physician with different sensitivities and specificities, right, at different times, in different formats, with different ways of intersecting with the emerging field of electronic medical records. This is what the physician looks like, right? This is your, in this case, oncologist say. She's got a headache. And she's got a headache not because actually she's got 5 reports, but if you're following the IP, she potentially has 100 reports, and they've come in not in that 2-week period where the patient is really eager to find out what's the treatment recommendation, right? They've come across her desk over a 6-week period, and they're really difficult to correlate, really difficult to correlate. And this oncologist has to do it not just for the patient in the examination room, but for 35 more patients sitting in the waiting room. And remember, this is an oncologist who's got some, but not infinite, for sure, training in genetics or genomics. They have to process this information. It is exceedingly difficult. We talk about biological actionability quite often in molecular diagnostics. That is, if you learn about a mutational status, does it mean anything as a medical matter? Because there may not yet be a treatment. It may not be medically actionable. But in this context, I like to think about professional or healthcare actionability. Is it realistic to expect a physician to assemble this vast quantity of information if that information has been assembled in a kind of balkanized setting driven by intellectual property divisions across rights holders? So these are all reasons why testing increasingly must be multiplex. The biology of disease states, the limited quantities of biopsy material or other ways of getting DNA, and the need for physicians to assimilate vast quantities of report information. It has to come from a centralized test, and many companies are moving in that direction. So when the patent law meets the genome, you get language like this that came out of the Secretary's Advisory Committee. And they, in fact, talked about a solution that I think most of us found potentially problematic. They wanted an exemption for the deployment of IP in molecular diagnostics, right? That was their solution. But here's their description, and I wanted to make this part of the stage setting of the problem. Multiplex or multi-gene test developers in particular face these numerous challenges in quantifying the size or the thickness and hacking their way through the patent thicket. Because these multiplex or multi-gene tests infringe typical patent claims on genes and associations, to market a multi-gene test without being sued for an infringement, a test developer would need to license those patents infringed by the particular molecules used on the actual test. The alternative of leaving patented genes off the test as a way to avoid infringement liability kind of flies in the face of the need for comprehensiveness. And it would be anathema for a physician to say, we didn't actually look for a particular actionable mutation in your sample because the lab was inaccessible to us because of IP reasons, right? The number of licenses that a multiplex test developer would need to obtain depends on how many genes you put on the test and the number of patents that are associated with those genes. Assuming a developer wanted to test for many genes causing a single condition or a constellation of conditions, the developer would need many licenses in order to make, use, and sell the test. So about a year ago, in celebration, I think, of the genome's 10th anniversary, I was interviewed in Science magazine, and this is what I had to say in an article titled "The Human Genome Patent Project." For a hypothetical 100-gene test in cancer, when I took a look at this patent landscape, it appeared grim to me. Investigating, and I mean full-bore FTO, the kind of FTO, freedom to operate analysis, that we're accustomed to in biotechnology for a drug candidate. Full-bore FTO, examining all the relevant patent claims, meaning issued and pending applications, and again, methods of detecting and isolated genes and genes used as components or probes and primers of the test itself. It seemed to me would cost about $35 million, and we did that by figuring out how long it would take and how much time it would take to do it for 10 representative sampled genes, and then we extrapolated it up to 100. It calculated out to, I think, about 42 patent attorney years to do this. So I told my patent lawyer, I can lock you in a room for 42 years and I'll see you then and you can give me the answer, or we can get 42 of your colleagues in a year, we get the answer. But in any case, it was an amount of money that simply made that kind of strategy a non-starter. So these were the kind of conclusions that we drew from what appeared to us to be a kind of boiling of the ocean, right? Analysis of these potential patent thickets for, say, 100 biomarker tests really represented what happens when the patent statute collides with the genome. And you get these thick thickets. And even after near impossible triage, right, starting with a kind of Boolean search that hit 40,000 patents, and then you triage your way down maybe to the 500 or so that appear to be the most thorny or the most difficult to work with, you still don't end up with very much that helps guide your scientists or business people. If you do the robust FTO, it's prohibitively expensive, there's no doubt about that. It's impossibly time-consuming. It doesn't suggest any sort of omnibus or broad workarounds or design arounds. Really, biology doesn't lend itself to that that easily, unless we synthesize, according to Dean, but that's still coming. We didn't feel that we were capable of materially reducing litigation risk for potential clients. And all of this FTO work, as many of you in the room know, it's essentially devoid of information that leads you to the actual rights holder, right? These things are being aggregated or spread around via assignments, sometimes recorded, via licenses, never recorded. And so actually getting to who you got to call is an enormous, enormous problem. And even if you could solve all of that, the prospect of one-off licensing was logistically and economically just impossible. It doesn't address the economic challenges of royalty stacking, and Francis Collins had said that he feared the $1,000 genome with a $100,000 royalty burden, and that appeared to us to be a serious problem. It's part of why we were interested in the patent pooling discussion, and it didn't at all obviate the need for an army of lawyers and business professionals to try to get that kind of licensing scheme established. Final word on the possible solution involves one very creative and interesting group, MPEG LA, that has tremendous expertise in pool aggregation in the high-tech, non-biological space. And they've announced a couple of years ago and have been working toward something called Librasi, which is a genomics or IP supermarket in the molecular diagnostic space. There are, I think, significant challenges, notwithstanding their creativity and dedication, in the kind of pool that they're putting together. In particular, they want would-be licensees to come to them and say, what patents do we need? And then we'll go contact rights holders. And of course, if I want to spend $35 million, I can tell you. But the problem is there are no standards. If you want to make an iPhone, I can give you a list, long as it might be, of the IP needed to assemble an iPhone. But I can't give you, without spending $35 million, I calculated, a list of the IP that's needed, and not spending 42 years, right? A list of the IP needed to be confident that you're not treading into infringement territory. And, you know, as we heard Seth Waxman say in his talk this morning, precision is critical, right? And the Librasi motto, trademark, it seems, is pathway to precision, right? And I hope from the conversation that's about to take place, we have an opportunity to talk about whether there's actually precision in this sort of approach to patent pooling. Thank you very much.
Thank you very much. Our next speaker is Gil Ohana, who is Senior Director, Antitrust and Competition for Cisco Systems. So from this role as antitrust advisor to the leading manufacturer of networking equipment for the internet, Gil can offer a different industry perspective and technological perspective, perhaps, on patent thickets from an industry that has confronted similar issues ahead of the life sciences industry. The IT field and the internet field have had to think through antitrust and other issues relating to joint ventures, standard setting, intellectual property, antitrust, and other issues. Gil is someone who writes and speaks regularly on licensing, standard setting, antitrust issues, and patent litigation, and other subjects at the intersection of antitrust and intellectual property law. Previously, he served as a trial attorney with the Antitrust Division of the Department of Justice, where he participated in the division's investigation of Microsoft's software licensing practices and its successful court challenge to Microsoft's proposed acquisition of Intuit. So similar issues, perhaps from a different technology and industry perspective.
Thanks, Rebecca. Find the mouse, the cursor. Sorry, I can't see the cursor, so I can't get the slides.
Let's escape.
Thank you. Thanks, Rebecca, for that introduction, and thanks to Stanford and WilmerHale for inviting me. As Rebecca said, I'm Cisco's antitrust lawyer. Cisco is a $43 billion a year manufacturer of networking equipment, and one of the things that we live with every day is a patent thicket. So I guess from the comments that we heard over lunch, and from Rebecca's comments and Gary's comments about maybe the trend in biotech, I guess I'm sort of the ghost of Christmas future in terms of what may await you. Because at Cisco, we do live in the middle of a dense, thorny, thick patent thicket at the intersection of semiconductors, computing, software, telecommunications. And it's a thicket that's inhabited by predators who occasionally sue us, maybe more than occasionally. One of the ways we deal with the patent thicket in which we live is through the formation of patent pools. And I'm active both in advising my IP colleagues regarding pool formation issues and also actually sitting in pool formation meetings sometimes, including in a number of ongoing wireless pool formation efforts that are happening right now around, for example, 4G wireless. And what I'll talk about today is the tech industry experience with patent pools and what lessons that offers or maybe doesn't offer for biotech. How many people in this room have participated in the formation of a patent pool? Okay, so maybe it's helpful to actually go through what a pool is. A pool is essentially the aggregation of patent rights among multiple patentees who contribute the right to license patents, and sometimes the patents themselves, to an administrator. And the administrator serves as essentially a licensing agent and also collects revenue from licensees and participates in the marketing of the pool, which means identifying people that are practicing the pooled patents, inviting them to license, and if they don't accept the invitation, enforcing patents against them. From that simple description, you might wonder why it often takes a year or two or three to form a patent pool. It seems like a pretty simple structure. And the reason is that under that very simple diagram is a lot of complexity. Some of the issues are around what royalties the pool is going to charge, which I analogize to the process of fitting a fitted sheet on a bed when the fitted sheet has shrunk a little bit, because they're typically a heterogeneous set of interests among people who participate in pool formation. Some see themselves primarily as licensors, some see themselves primarily as implementers, but want to make some royalty income to sort of help defray their implementation costs. So there are going to be a range of interests, and some people in the room are going to want lower royalties, some people are going to want higher royalties, and the thankless task of a pool administrator is to try to figure out a point that pleases everyone in terms that please everyone. Typically, patent pools allocate received revenue based on proportionality, so if I've got 4 of the 100 patents that are essential to implement a particular standard that are represented in a pool, I'll get 4% of royalties. That's typically subject to a lot of adjustments, such as an adjustment for joining the pool early, adjustments for actually making patents available for enforcement, because one of the risks in a patent pool is that the pool will go enforce your patent, and it'll turn out that the patent's invalid, for example, and pools don't assess validity on the way into a patent pool. They do assess typically essentiality for a standard. There are interesting geographic issues in worldwide pools because companies patent geographically differently, and so someone may have 5% of patents that are essential to a particular standard in the United States and 10% in China. So if a product is manufactured in China and sold in the United States, should they get 5%, 10%, somewhere in the middle? These are issues that pool discussions often go very deeply into. The pool administrator is in an interesting role of collecting money, but typically because of antitrust reasons, not disclosing to the members of the pool exactly what the revenue base is for the royalties that it's collecting, which involves a lot of trust to the administrator. The administrator is negotiating its own fee. Administrators don't do this stuff for nothing, and they want to get a cut of received revenue, and figuring out what that amount is going to be is itself a negotiation. So forming a patent pool takes a while. I've been involved in an LTE effort that's now in its probably 30th month of pool formation, and we're getting pretty close, but may work out, may not. In the tech industry, and I was thinking of this during Andy's comments at lunch about the emerging biotech standards or whether biotech standards will emerge. In the tech industry, pools are generally formed around standards. For example, MPEG-LA, which Gary mentioned earlier, has a very successful patent pool for the MPEG-4 or H.264 video codec, which is a very widely implemented video codec out there. And the nice thing about forming a pool around standards, and this goes to some of the things Gary mentioned as well, is that the standards development process typically involves a finite set of participants. People show up at meetings, they discuss the technology, they contribute patents. Under the rules of standards development organizations, you know who has declared patents to the standards development organization, and therefore, when it comes time for the pool administrator to go start a pool, it knows who to go to say, you, Cisco, were an active participant in the third generation platform partnership. When they created LTE, are you interested in joining a patent pool or coming to meetings around the formation of a patent pool? So there's a set of people you can go to. So we don't face to quite the same extent the issue that Gary mentioned about not knowing who owns IP rights. We obviously don't know perfectly who owns IP rights because there are people who often own IP rights who don't participate in standards development. But we do know among the companies that participate typically who has patent positions in an area, and those are the people that the administrator typically reaches out to invite to participate in pool formation. Some of those companies will choose to participate, others may not. One of the really fascinating things, in which Gilbert may talk about this, I know it's something he's written about, is what companies join patent pools and what companies don't. And it's an interesting sort of bell-shaped curve. Companies with a pure IP enforcement model are extremely unlikely to join a pool. Companies with an entirely defensive IP model are extremely unlikely to join a pool. So pool participants tend to be kind of the muddle in the middle. Companies that both have some IP licensing as a business model, but also may do a lot of implementation of particular standards. And even within that group, like any bell curve, there's a range of interests. And as I mentioned before, people may differ in terms of their trade-off between the royalties that the pool will charge and therefore the income the pool will receive versus their implementation costs. Sort of talked about this already, so I'll move on. One of the really interesting issues around pools in the tech industry is enforcement. And the reason it's an interesting issue is because the administrator typically wants to preserve a lot of independence relative to who it enforces against. And what the great thing for the administrator is if all the participants say, yeah, you can enforce any patent I own that I've contributed to the pool against any third party. In my experience, very few participants in patent pools are willing to do that because you don't want your patent asserted against your strategic partner, your contract manufacturer, the company that you're about to acquire, et cetera. So typically, companies want to maintain very tight control over assertion, which is why pools typically pay what are called enforcement bounties or enforcement bonuses that favor, in terms of a greater share of revenue, pool participants that actually are willing to step up and say, yes, you can have my patent, you can assert it, I don't want to know about it, go take it and go to town. Typically, participants want to maintain high control over that, and the pool administrator will come back and say, look, if you want me to make money for you, I've got to be able to actually threaten to sue people, which means I've actually got to have patents that I can use to do that are strong patents, that are owned by members of the pool, and that will scare people into actually taking a pool license. And that is a very difficult negotiation in pool formation. Let me talk about a slightly different structure, and one that maybe will have more appeal in the biotech world, which is a patent platform. And the line between a platform and a pool is a little bit amorphous. What Gary talked about with respect to the MPEG-LA effort, I think I would describe as more of a platform than a pool. And the distinction that I would draw is a pool is a set of patents where there's a reason why a prospective licensee would want the whole basket, because they're implementing a standard, for example, and they know that they need an entire set of complementary essential patents to implement the standard. A platform is more of a shopping cart in which you can put patents, and all of the patents have agreed to be licensed under common licensing terms, which may or may not include price terms. But a bunch of patentees have gotten together and said, we're going to agree on a common form. Maybe that form includes pricing. Maybe it includes benefits from a pricing standpoint if you license pools in multiple areas or multiple patents. But it's more of a standard set of licensing terms as opposed to a single set of terms for a basket of patents where the expectation is that you will take all of them. There are examples of patent platforms in technology. One of the leading ones is the third generation patent platform partnership known in the industry as 3G3P, which was a patent platform formed for the implementation of a number of 3G wireless standards, UMTS, which is the 3G successor to GSM, the 3G successor to CDMA, and a number of other wireless standards that are practiced in the world. It was a subject of a business review letter, which I can send anybody if they're interested. And patent platforms can raise interesting antitrust issues because the basic antitrust justification for patent pools is the pooling of complementary assets such that you reduce negotiating costs. Those efficiencies tend to be a little bit weaker in patent platforms because of the weaker complementarity between the constituent patents that are available through the platform. As I mentioned before, based on what I read about the MPEG-LA effort in biotech, it sounds like more of a platform than a pool. And that may make sense in the world of biotech because absent, the nice thing about standards relative to pools is that a standard essentially forms the dimensions of a patent pool, the meets and bounds, if you will, of the patent pool in terms of this is the set of patents that an implementer will likely need, and therefore this is the set of patents that more or less we're going to include in the pool. Absent that kind of structure, you're going to have to leave it to licensees to decide which constituent elements they're going to want to take, and licensee preferences may very well differ. With that, I'll sit down. Thank you.
Thank you very much. Our next speaker is Professor Richard Gilbert from the Economics Department at UC Berkeley. Professor Gilbert is a leading authority on the economics of the antitrust laws as applied to intellectual property. His work on patent thickets and patent pools is widely cited and has been enormously influential. He's also had considerable influence on this area as a public servant from time to time. He served from 1993 to 1995 as Deputy Assistant Attorney General in the Antitrust Division of the U.S. Department of Justice, where he led the effort that developed joint Department of Justice and Federal Trade Commission antitrust guidelines for the licensing of intellectual property.
Thanks, Rebecca. So I'm following Gary, and who knows a lot about the biotech world, and Gil, who lives in the trenches of the IT world. And my objective here is to kind of put these worlds together a little bit and talk about what their implications are for resolving patent thickets and for possibly using patent pools or platforms as a solution to patent thickets. And then I also want to talk a little bit about damages because in my view, it's closely related to that issue. So I want to run through several reasons why, in my view at least, well, clearly we have not seen patent pools emerge for biotech, and reasons why the obstacles are somewhat higher in biotech than for information and communication technologies. One, as both Gil and Gary said, we don't have standards in biotech. They might come, as Professor Endy said, we might see them in the future, but we don't have them now that I'm aware of. And when you have a standard and you have many patents that have been declared essential for the standard, it creates a clear need for anyone who's implementing that standard to have access to all of those patents. And it also means that if you're a patent owner and you see someone who is implementing a standard and you know you have a patent that's essential to that standard, you know who to go after. So there's a clear incentive on both sides to participate in a pool, at least from that, for that reason. The number of patents involved in information and communication technologies is often enormous. The number now, I think the last number for MPEG-LA was, what, 860 patents or something like that? And who knows how many patents have been declared in the cellular space. I've seen estimates anywhere from several hundred to many hundreds of thousands of patents that are arguably essential to implement different standards in that space. So the need to get access to all of these is somewhat greater in information and communication technology. It's not absent in biotech. Another point, this is a point that I think has been made elegantly by Professor Eisenberg, is that biotech has a lot of dispersed users with relatively low commercial values. And the transaction costs of identifying these users and demanding royalties is often high relative to the royalties that you're actually going to get from these users. So it means that a strategy of sort of lying low and waiting for someone to get you is often not a bad strategy in the biotech world, but not one that's going to work if you're a Samsung or an Apple or something like that. Now, another problem that's related to standards is that you don't really know what a pool would be created for. There's, on the issue of formation of pools, there's a huge diversity in business models. A lot of biotech tool patents arise from innovators, pure innovators, universities, research institutions. They want to collect royalties. Then you have your pharmaceutical companies that want access to the patents, or some people involved in research. But you have this dramatic difference in business models. You also have that, of course, in information and communication technologies, but there's at least a critical mass in some fields where a critical mass might get together and form, put enough patents into a pool to make the pool viable. There's no pools that I'm aware of that include every patent that is essential for a technology, for a standard. But there are enough to make it worthwhile for the pool to generate some transaction efficiencies. Another problem is patent valuations, very difficult because the long lag between biotech patents and actually coming out with a product. Whereas if you're developing a standard, you got the standard. In the ICT, information communication technology world, is actually often the opposite. You have the standard, and now you're going to have patents emerging on that standard, and you can see right away the need for some aggregation of access to those patents. Whereas in biotech, maybe you have a patent, but you don't know what it's for yet, and it's hard to know what to actually form the pool for. And that raises antitrust issues, because in the pools that have been formed, the antitrust authorities have taken comfort in the fact that there's a declaration typically of essentiality to join the pool, and if the patents and technologies are essential for a standard, it means that in competition speak, they don't really compete with each other. Whereas if you just have a bunch of research tools, they may well compete with each other, and putting them all together now raises competition problems. One of the antitrust actions in this space was an action against the Summit Pillar Point pool for laser eye surgery, where the argument was that it was putting together patents. This pool was putting together patents that were substitutes for each other, not patents that were all essential to do this type of laser eye surgery. So it raises a lot of antitrust issues as well. Now, that's not to say that pools just sort of magically form in the ICT space and they're real easy and they include all the technologies. They don't. They're rather infrequent. There are a lot of obstacles to forming pools. When they do form, they are invariably incomplete. But in order to have a pool, there's got to be a demand for the pool. It's got to be the case that the costs of forming the pool are less than the value that the pool will create. And I think so far we just haven't seen that in biotech. And you have to overcome the potential antitrust issues as well. It might happen, but we haven't seen it quite yet. And you add to that, there's also been a tradition of sort of ignoring patents a little bit, which is related to the issue of there aren't a lot of royalties to be collected, sometimes relative to the costs of enforcing a patent. So a strategy of ignoring patents has been, in some cases, not, a potentially viable strategy, at least until you get caught. Now I want to talk a little bit about damage calculations, because they're actually closely related to the benefits of a pool. When you think about a patent thicket, patent thickets create several types of potential economic hazards. One type is the transaction costs of assembling the necessary patent rights, that is, navigating this patent thicket. A second problem is what's called royalty stacking. It used to be called the Corno-complements problem, but that doesn't roll off the tongue very well. And what royalty stacking really refers to is that not only do royalties go up as the number of patents that you need licenses to goes up, but you can actually wind up paying an amount that is greater than the profit maximizing price for all of those patents. So if you put them all in a pool, the total royalty actually can go down. And a third point, which I think is really hugely important, it's not exactly royalty stacking. It's when you have patents that are all essential for a technology. You have a situation in which every patent owner can legitimately argue that its patent has all the value, creates all the value. You need me. And it's true. When patents are essential, you need all of them. That's what essential means. So if one patent owner has 50 patents and another one has one, arguably the patent owner with one can say you need my one as much as you need that person's 50s. And that sets up a very destructive bargaining situation, and one in which you can wind up creating bargaining demands that are completely disproportionate to the value of the property, the intellectual property. This is a type of royalty stacking, but it's separate also from royalty stacking because it can be much worse than what we normally think of as royalty stacking. I would argue that reasonable approaches to damages can address this third problem this third type of, I call it a holdup problem, which is not actually standard-related holdup. It's holdup that comes from the existence of all of these patent rights. You can deal with that. One way to deal with it is to form a patent pool. If you form a patent pool, the pool has to decide how to allocate the licensing revenues among all the participants in the pool. So you have to address this problem of allocation. Another way to deal with it, which can make the pool less necessary and still accomplish a lot of the benefits, is to get courts to be reasonable about patent damages. And we're seeing that in the courts today. There's definitely been a movement to take this more seriously. We see that in a number of different cases, starting with Luciano and Judge Huff, and then Judge Rader in different cases. Hopefully the burying of the 25% rule, I hope that's gone. And what we need is not so much a simple apportionment rule that says everybody gets their share of value depending upon how many patents that person owns, but rather common sense. So when someone comes in to a court and demands a royalty and has 2 patents for a product that necessarily would infringe 100 patents, 200 patents, 500 patents, that there's, or go up.
You can keep going up.
Yeah, right. That a court recognizes that this is not the only game in town, and of course, in addition to the intellectual property rights, there's everything else that goes into a successful product. And somehow the court recognizes and takes into account in a damage analysis that you don't get all the money. And if that were done, a lot of the benefits that can accrue from a patent pool, in my view, can be accomplished through a more rational approach to damages. And of course, patent damages then affect settlements because settlements occur in the shadow of what you would get if you did some kind of infringement exercise, and can bring a lot of rationality into the whole system. Thanks.
Thank you. Our final speaker is Robert Galvin from the WilmerHale law firm. Rob is a member of the Intellectual Property Litigation Practice Group at WilmerHale. His practice focuses on intellectual property litigation across a range of industries, so he has a foot in both of these camps. He represents innovative companies in the life sciences industry as well as in the software industry. He has tried patent cases in various jurisdictions around the country. He also has substantial experience advising clients in licensing and antitrust and unfair competition issues, and he's given a lot of thought to this problem of patent valuation issues and the relevance of recent developments in the law of damages to these problems. So,
thank you, Becky. So I'd like to cover 2 things, building on what Richard just said as well. First, I'd like to just talk briefly about some developments in the law recently from a litigation perspective, and make this the modest case that there's been some developments that are more favorable for the formation of patent pools as part of a solution to the patent thicket problem. And then second, I'd like to focus on the issue of damages case law and the extent to which the developments in the damages case law have made greater predictability and greater apportionment of the relative contribution of patented technologies in ways that would, again, be beneficial to patent pool formation and valuations of patents. And so on the first point, just briefly, I wanted to talk about just some of the factors that you could identify as influencing the formation of patent pools and the desirability of patent pools. And I just wanted to highlight a few quick developments in the case law that I think are relevant to this inquiry. The first that I wanted to focus on was patent strength, and we spoke about that this morning in terms of the Mayo decision. So to the extent to which in the diagnostic space, for example, there is now greater uncertainty about the strength of your IP, I would make the case that perhaps some companies may be more incentivized to be considering patent pool solutions, standardization, whereas in the past they were more willing to bet their strategy on an enforcement strategy, and that if that is dialed back to some extent, you may see at least greater receptivity for some companies to be considering that as a possibility. Injunctive relief availability is another, I think, obvious one. To the extent to which diagnostic companies or other life science companies could traditionally rely upon injunctive relief, you have the problem of holdouts from a patent pool. If I can keep you off the market, I may be able to wrest from you a premium that is higher than the value of my technology to you and to your product. And of course, the Supreme Court's decisions in eBay and the gradual limiting of injunctive relief, at least particularly to non-practicing entities, to some courts being more receptive to arguments regarding public interest, puts more of that, I would say, in play than it was 3, 4, 5 years ago. And the other point that I think is an interesting one to look at is in terms of business model of licensors, in terms of the influence that may or may not have on patent pools. What I expect that we will see in the future is an increased presence in patent aggregation firms in the life science field. That is something that we've certainly seen on the IT side with firms like Intellectual Ventures and others being very aggressive in accumulating IP. And I think sort of it's a double-edged sword here. On one hand, the extent to which you have an increased holding in IP by firms who are not practicing inventions, not bringing products to market, as it was pointed out, I believe by Gary before, that those firms typically do not have as much incentive to enter into patent pools because they have no products that they're trying to bring to the market, and their strategy is to monetize and to wrest as much value through their IP as possible. On the other hand, in terms of an issue with respect to the patent thicket, as you see some of these firms being able to aggregate more IP, the value that they will proclaim that they can bring is to solve some of the thicket by having bought up a big chunk of the thicket. And they then will be able to leverage that potentially in terms of in the diagnostic space or in other areas, and an argument that if you come and license from us, a substantial portion of the pathway through the thicket will be cleared. And I think there's already been efforts by some of these firms to look at the academic communities and other places to sort of effectively say we will manage your IP, or we will trade you value now and manage that for you. And so I think that's sort of another interesting development that we'll see if that encourages encourages the clearance of the thicket or makes the thicket more difficult to manage. But I wanted to focus the last set of my remarks on measurement of damages, and in particular, this question of how we get greater clarity and greater certainty about damages calculations. And because I agree that is an important part of allowing firms to properly value their IP in the context of a patent pool, and is essential for that to go forward. So I just wanted to cover a couple of brief things regarding reasonable royalty analysis. So there is a long set of factors in the law, the Georgia-Pacific factors, which some of you are aware of. 15 different factors, and there are lots of different ways to formulate this. But I think there really can be boiled down, and Mark Lemley and his colleague Darryl Nduri had a nice article that came up with this framework, which I thought was helpful. What is the analysis? It's what is the nature of the patentee's business? What is the incremental value of the patentee's technology over non-infringing alternatives? What other inputs contribute to the infringing product, which is a question sort of apportionment of how you apportion the value, and what actual royalties have been paid for the same or comparable inventions. Now, I would argue that is a relatively well-reasoned framework for attacking this problem. Now, one can question whether that is in fact what happens in the courts across the land in cases where the analysis becomes left to a jury with very little guidance in terms of how to answer those questions. A jury in the typical case will be given a long laundry list of factors to consider. They're given relatively no guidance in terms of how to weigh or balance those factors. There's very limited ability to review the determinations of the jury because under our case law, we allow that in constitutional issues as well, that the jury will decide the issue of damages. And so there's very little ability for the appellate court to check that once it's been submitted to the jury. You have a phenomenon in terms of if this is a jury trial of tunnel vision and what I call the Lake Wobegon effect. If you're looking at the patent, every patent that's being tried in a case is above average, it's worth more, it is essential. And if 2 or 3 weeks of a jury trial have focused on the story of the inventor and how great it was and how this company is using the technology, is it any wonder that the valuations that are going to come out of that process are going to be biased in a way that's going to significantly potentially overvalue the relative contribution of the patented technology? And then there are some practical litigation constraints that I think are significant, which create a problem with coming up with good valuations through a litigation process. One of the points that was made was it would be very helpful and very important for an analysis to focus on the scope of the IP, the number of patents that would need to be practiced to develop this diagnostic test or this iPhone. And certainly as a defendant, you would like to argue, well, we have 2 patents at issue in this case, but really there are 500, 600, 800 patents. Now just, if you think about that, it's completely right on the economics and it's completely right on the analysis. How do you present that at a trial? First of all, if you're the defendant, which patents are you going to admit you already practice? We're getting down to brass tacks here. Are you going to make that admission? Secondly, in courts across the country, you may have 8 days, 6 days, 7 days, 9 days, if you're lucky, to put on your case, your liability case, your damages case. So we're going to prove up that we use 700 patents and what their valuations were and what, there are real significant issues that make this very difficult. And as a result, potentially overvaluing and rewarding those who want to hold out and have a model that is going to focus on trying to recover through litigation. Now, luckily, there's some good news, and as many of you are aware, there's significant progress that's being made, limiting reliance on the entire market value rule. There's a series of decisions by the Federal Circuit and Lucent and Unilock, focusing the inquiry, at least trying to give guidance that we should be looking at what is the patented feature or component driving customer demand? Is it the basis for customer demand? There's a series of decisions that have come out recently in excluding expert opinions. The courts, Federal Circuit leading the charge on that, saying that the courts need to take more seriously their gatekeeper function to try to keep out, at least guard from some of these opinions from coming in before the jury, rejecting the 25% rule of thumb, raising the standards for willful infringement. These are all positive developments in terms of improving the process, but I would submit that there's still a lot of work to be done. And there's one thing when you read the opinions of the Federal Circuit of the approach that should be followed, which is, I can't disagree with any of those points, but when you actually see how a trial occurs and you see the expert get on the stand and they go through the 15 factors and they go, that enhanced it, that decreased it, that, and then a number appears. And then it's sent to a jury who will then return a verdict, and if it's typical practice in most courts, where a number is just filled out. No special interrogatory verdict detailing any of these special findings that would seem to be required by the case law. And so a few just thoughts in terms of things that could be improved in terms of measurement and damages and how I think this would help managing the patent thicket. One would be to simplify and distill down the factors for the jury to consider. I think for so long we've relied on these Georgia-Pacific factors, which I recommend that you read them, and if you think you would have any sense of what you're supposed to do after reading those, then you're much smarter than I am. We need to give the jury more guidance if we want to get a rational result to come out of this process at the end. they should be required to use special verdict forms. There should be a requirement so that there's some ability to review if fundamental errors have been occurring. There needs, and this has been suggested in the case law, but more requirements that demand for patented components and be assessed using survey evidence, for example, to really show that there is true customer demand. Looking for more ways to make this an empirical test as opposed to someone saying, well, it must have been valuable because they're using it in their product, which is what most of the analysis is to date. And then some thoughts in terms of avoiding the royalty stacking problem. Certainly, it would be useful to identify the number of patents covered by an accused product. I would love, when I'm representing companies, to be able to present that kind of evidence, but we need to think through, how are you going to be able to do that? It's almost like you have immunity to be able to raise these issues in terms of the defense analysis without creating all sorts of other liabilities for yourself down the line. And then the last point is just, I know there's been academic discussions of this, but it seems like a very sort of sound analysis point in terms of standards cases. Shifting the hypothetical negotiation date from the date of where the first infringement and first use occurs to the date that the standard is set. You have a real problem once standards are adopted, and then you have people coming in later with these IP claims. The extent to which there are some mechanisms creatively in the case law that we could use to take out that incentive to punish someone and allow them to take more money from a particular party just because they had adopted a standard. I think that would also be a very helpful development as well. With that, I'll sit down.
Thanks. We went on somewhat longer than I expected. I would like to open up the floor to questions from the floor. I think there's a lot of sophisticated people around the room that would probably come up with more interesting questions than we would pose to each other. John Duffy.
Thank you. I have a question about, is this on?
I can hear you.
I've got a teacher's voice.
Yes.
So the question mainly goes to Gil, I think, about patent pools. Because the relationship between patent pools and the baseline rules that they use are interesting to me compared to the damages baseline or sort of rules of thumb. Because in the damages area, as we all know, the baseline, the sort of rules of thumb that sort of sound like junk science, are being increasingly dealt with in a skeptical way by the courts, which I think is a good thing. And so I'm totally surprised to hear that market actors, when they're finding a patent pool, they start out by saying, as you said in your presentation, well, if I've got 3 patents and there are 100 patents, I'll get 3%. And that just as a patent scholar, that strikes me as wild. One thing is you'd say, like, do they make adjustments at least to account for how many? I mean, why use patents rather than, let's say, patent claims or, patent families? Like, if I have 5 patents that all came out of the same parent application, would pools normally count them as 5 or as 1? And even if you count claims or patents or whatever, it still has no correlation, absolutely none, to value, which is what we're trying to get at. So why do patent pools start with some sort of baseline that seems irrational like that?
Just one clarification, and I don't know if I was clear on this point, but I meant 3% of the pool revenues, not 3% of the price of the product.
Oh, no, I got that.
Okay.
3% of the pool revenues.
I mean, I think the reason patent pools use proportionality as a baseline for royalty calculations or royalty allocation is because the alternative is a bunch of people who say, my patent's really, really special. There's no magic around the use of proportionality. I just think it's easy and quick as an allocation device. It does lead to the phenomenon where people who genuinely feel that their patents are really, really strong, may not want to join pools. On the other hand, to go to a point that Rich made, ex post, all patents are created equal relative to they're all complements to implement the same standard. So proportionality may make a lot of sense in that sense because again, at the end of the day, I need all of them. I mean, it's always surprised me that the people who complain most about the current standard system are not people with really, really strong patents because their patents, I think, effectively get devalued because of the phenomenon that ex post, there's this great leveling, and weak patents get raised and strong patents get demoted. I don't know if that helps with the answer. In terms of the way pool royalties work out, there's a really fascinating graphic in a pleading Microsoft filed in its case against Motorola Mobility in Federal District Court in Seattle a couple of weeks ago. It's available on the indispensable Florian Mueller FOSS Patents blog, but it compares the H.264 patent stack and what Microsoft pays to license a whole bunch of patents that are claimed to be essential to implement H.264 with what Motorola is charging for a much smaller set of H.264. Motorola seeks to charge for a much smaller set of H.264 essential patents, and makes the point that if you were to apply the same valuation metric from the pool to Motorola's claims, they would be a lot lower, which I think goes to the fact that patent pools generally wind up being resulting in royalties that are significantly lower than at least what people claim in individual bilateral litigation or bilateral licensing negotiations. I have a feeling I haven't answered your question, but.
No, it's
But one clarification is pools differ in how they value patents in the pool. Some use numeric proportionality, but other pools use some sort of valuation, subjective/objective valuation method in which different patents do get different shares of the pool. And there's some evidence that that type of approach leads to greater participation in the pool.
But these things do increase the incentive for just filing a lot of patent applications.
Well,
To the
not if
extent
you
that
did-
think some patent pools use this as
It
the
depends
baseline.
on your valuation method. I mean,
Right,
if
but-
you looked at them and said, well, you know, this one patent has more significant claims than these 12, and we can value them in that way. So it differs from pool to pool.
And to go to another part of your question, typically it is done by patent family as opposed to individual patents for precisely that reason.
So they at least get that point, right?
You don't want to reward someone who's engaged in sort of aggressive divisional practice.
I've been privy to conversations among prospective licensors where one will say, look, I've got IP that attaches to a gene which, if mutated, there's zero medical consensus about what to do. And another rights holder will say, I've got a patent that attaches to a gene which, if mutated, there's a drug on the market to treat it. And so we've had conversations about whether you could use the gene actionability as a surrogate marker for value of the IP. Of course, that's a shifting landscape because every day we're learning more about the actionability of particular
Right,
mutant genes.
It seems easier in the biological context, because you could say, what's the probability if I know this that I can cure a disease, and you could use, like federal regulatory qualities or something like that in order to.
Those conversations have happened. It hasn't made forming the pools all that much easier, I must say.
The mic right behind you.
To what extent at all have any of you seen patent sale data points, of which there obviously are an increasing number and also an increasing magnitude, used as a data point for valuation of individual arguably comparable patents, whether that's in the pool concept, text rather, or in a damages context?
Great question.
Just an observation that it's really hard to get the data. Even in discovery, people fight you pretty hard before they provide it. The other thing is that usually in litigation, you're looking for a percentage or a per product price as opposed to the price paid for the patent, which then you would have to kind of divide up based on anticipated number of infringing widgets. So that the sale data would be a first step, but you then have to go to the next step, which is, okay, how many infringing products are there out there?
You know, while not always the case, in many cases, these acquisitions have been for defensive purposes rather than offensive, collect royalty purposes, not always, but mostly. And so one specific, you could think of, say, the CPTN aggregation, which is what Microsoft, EMC, Apple, or even Rockstar, in which they agree to cross-license each other at zero royalties. But you can think of that as a pool but a pool that, not a pool that is collecting royalties, but rather its value is through protection.
And there are other defensive, in the tech world, there are a lot of other defensive vehicles like AST and RPX where companies have gotten together to fund patent purchases, collective patent purchases. And I suppose that from the standpoint of you're willing to pay what you would otherwise have to pay to license, that may be an interesting benchmark.
I think the other issue is just comparability to the extent to which you're able to point to a sale of a technology and of a patent portfolio that really is targeted in a way that would be comparable to the patent that you're trying to value in the context of a royalty, then you'd have a stronger case. If not, if it's just a large portfolio that's going to be, mildly on point, then I think you're going to have more of a challenge coming from another party to say that this isn't comparable and therefore should be excluded under the Federal Circuit precedent.
Yes.
Just coming back to the sort of context in which we started the discussion around diagnostics for oncology or diagnostics for other diseases. As you think about the different ways you could slice up the spectrum for thinking about, okay, what is the standard, in the IT sense, but what is the standards upon which we're going to have an organizing principle for creating a set of patent assets that we can then have a pool or a platform from which others can access centrally and license. Do you think it's most constructive to think about it sort of on a gene by gene type approach, or would you think about it more from a sort of disease indication by indication, so pancreatic cancer versus breast cancer versus lung cancer as an organizing principle for how you might assimilate different pool constructs?
So I know that the MPEG-LA folks, whether it's a pool or a platform, describe it as an IP supermarket where you can essentially conceptually walk down a pancreas cancer aisle and pull off IP as a prospective licensee from the shelf and walk down a lung cancer or an inflammation or cardiovascular disease aisle and shop for the IP that you think you need as an organizing principle. So the disease state becomes the organizing principle. In oncology, it felt funny to me because the place where the tumor arises, the organ system where it arises, becomes less and less important the more you know about the gene state that's causing the underlying disease, right? If it's a HER2 mutation, it could be in lung or ovarian. It seems to me that there's kind of cross purposes there. It also relies upon licensees to say, I need this, but I don't need that. And I had a concern that there would be kind of a gaming of the system by prospective licensees saying, oh, we don't need that, because in the absence of standards, the debate takes place. Who needs what? And
it doesn't shift the level of effort that the licensee has to do to figure out what they need, as opposed to someone else has sort of done that work collectively, and that's one of the benefits that they get is not having to do all their
it does not.
all their diligence.
And I will say again, perhaps just empirically, since we haven't seen a lot of these pools, one can speculate why, and we can say perhaps the damages are sufficiently low, or biotechnology has a history of sort of using tools in a somewhat opaque and obscure and perhaps infringing way, but we don't talk about it. It's pretty clear in the presence of things like Prometheus, in the presence of things like ACLU v. Myriad, that business people, seeing the shifting context, right, seeing, for example, the Secretary's Advisory Committee say, we need to pass a statutory exemption for the diagnostic use of gene-related IP. They're business people, these entrepreneurs, these bio-entrepreneurs, my best friends, they're not this room, frankly, and they don't sit politely this long through a conversation about gene-related IP and patent pooling. And they basically say, I think as you might have said, Richard, we're just going to wait and see who clobbers us. And when, part of the other truth about thickets is as they get bigger, conceivably the piece of the pie gets smaller for any one bidder rights holder. And so the notion that you're going to actually have enough skin in the game to mount a significant litigation effort for relatively small or diluted dollars diminishes. And so it may be that the thicket itself and the size of it has such an impact on potential damages that, that we just can't get organized around this, and that may be the answer.
So I think we are miraculously right on time, and so thank you very much, gentlemen, and with that we'll conclude.